The standoff over governors, constitutional lawyers have warned that complete disregard of court orders by Parliament would be a recipe for chaos and a threat to the rule of law. Legal experts now urge the President, the Chief Justice and Speakers of the Senate and National Assembly to urgently convene a constitutional conference to interpret the law of a separation of powers.
It is natural that they will jostle for supremacy.
The standoff triggered by court orders against Senate summonses on governors has reignited the debate on which arm of the government has the power to stop the actions of the other and whether the governors should heed orders issued by the Senate. Article 125 of the Constitution gives either House of Parliament and any of its committees power to summon any person to appear before it for the purpose of giving evidence. In exercising that mandate, Parliament and any of its committees enjoy the same powers as the High Court. The question is whether the High Court was interfering with the Senate by blocking senators from grilling governors.
It's very critical for governors to have an institution which checks their excesses, especially when it comes to expenditures. But remember, it is within their constitutional right to go to court and challenge whatever decision, whatever process has been initiated by any other person.
The Senate thinks that they're equivalent to the judiciary. No. It is limited to the ability to summon anybody, and anybody includes the President. Remember that the oversight role involves very powerful people in the executive. Therefore, to be able to get there, you must have that strong power. Now, when the High Court stops them from exercising that role, we are creating a conflict.
Article 96 of the Constitution gives power to the Senate to determine the allocation of national revenue among counties and exercise oversight over national revenue allocated to the county governments. But governors insist the Senate has no power to summon governors or members of the county's executive on matters of financial management. Governors argue that oversight role should be exercised by respective county assemblies.
The individual county assemblies, their oversight role is limited to the residents of those counties. But to the extent that the governors are handling money from the people of Kenya, the organ that we elected to look at that is the Senate.
Standing in solidarity with the Senate, members of the National Assembly said the judiciary was overstepping its mandate by issuing orders which were not in line with the tenets of separation of powers. Some officers of the judiciary were accused of engaging in judicial activism.
This is a new judiciary where the judges are thoroughly independent. They have made numerous orders against the President. It is not that they are being activists. They are actually being thoroughly independent.
Judicial activism is very critical, especially when it comes to implementation of a new constitution. That is key. However, extreme judicial activism may be very dangerous for probably a newly established constitutional order.
In a move to flex their muscles, members of the National Assembly unanimously agreed that the allocation to the judiciary be slashed. The Senate said it will comply with the court orders, but then postpone discussions on key finance bills that will allow movement of cash to county governments. Senators also warned they could initiate measures to close down some counties. Patrick Amimo, KTN.